Bismillahirrahmanirrahim and welcome back to lecture number 7, part C. In lecture number 7, we are discussing the different modes of membership, different kinds of shareholders, or how a person become a shareholder or member of a company. The first that we have already discussed is membership by subscription. Second is membership by application. And now in part C, we will discuss membership by transfer. Membership by transfer is that kind or mode of membership or shareholder in which a person become a member or shareholder by purchasing the shares from the shareholder, not from the company. So in this type of membership, a person purchases the share not directly from the company but from the existing shareholders. If a person purchases shares from a shareholder, he becomes a shareholder and is entitled to be placed on the register of member in the place of the transferor. So the one who transferred the share, his name will be deleted, and the one to whom the shares are transferred, that is transferee, his name will be entered. So date is most important. At that transfer, the date will also be mentioned, because from that very date, the liability of a new member will be started and the liability of the previous shareholder will come with it. As we know that in public companies, the shares are freely transferable, but the mode of transfer is left to be decided by the articles of association, how they will be transferred. So there are few striking features of this type of membership. The first is that a person purchases the share from the existing shareholder, number one. Number second, he purchased the shares indirectly, that is not from the company, but from the shareholder. Third, if he purchased the shares in the result of misrepresentation, then he has the right to cancel his membership. When the shares are transferred, his name will be entered in members register and he will become a member in a proper way. The fourth type of membership is membership by succession. By succession means that is in case of the death of a shareholder, his shares will be distributed among his legal heirs according to the law of inheritance. The heirs of the deceased shareholder or the official assignee, in case of any insolvent, become entitled to be member in place of a deceased or insolvent person. So membership by succession is of two types. First, that is by inheritance, that is in the death of a shareholder, his legal heirs will become members of the company. So that membership is not by the consent, not by an agreement, but it is in the result of an operation of law. It is in the result of a Quranic formula, that in case of death, his legal heirs will automatically become the member of the company. Second type of membership by succession is that if a person is declared insolvent. As you know that what insolvent means, when the debts and liabilities of a person are more than his assets, he can apply to the court and he will be declared as an insolvent. Then all of his shares will be transferred to official assignee. Official assignee is a person that is appointed by the court who will take charge of all the property of the insolvent persons. And shareholder is also the property that will also will be transferred to the official assignee. So official assignee are the legal heirs. They are become the members of the company by operation of law and not in the result of an agreement. Such shareholders also got the shares indirectly from the company and not directly from the company but from the shareholder. The transfer is based upon the acts of the parties. As we have studied, the transfer when with the consent, when one person agrees to transfer his share to another. While transmission is the result of the operation of law, as that is in the succession, that is in the result of operation of law. In the case of transmission of shares, they continue to be subject to original liabilities. So whether that is membership by transfer or membership by succession, if there is any liability attached to the shareholders with the transfer of their shares, the liability will also transfer to the new shareholder. In these both cases, the name of the new shareholder will be entered in members register. Then he will become a member of a company. Last one type of membership is the membership by estoppel. Membership by estoppel is basically a principle of law of evidence. According to this principle, if a person gives a statement and another person on the base of that statement enter into a transaction, then that person who gave the statement cannot deny that it is not true. In law of evidence, when you give a statement on oath, when you record your statement on oath, then you are stopped from denying that statement. Once you record your statement in the court, whether civil court, session court, then you cannot deny. You are stopped from denying that statement. In the same way, membership by estoppel is that when a person may be deemed to be a member of a company if he allows his name to be on the register of members or otherwise hold out as a member. For example, Mr. A is not the member of the company, but Mr. B introducing him as a member of a company and Mr. A do not deny that I am not the member. Then afterward, any liability arises, the Mr. A will be held to be liable for the liability as just like an ordinary member, although he is not a member. It is a very technical one. Membership by estoppel means that where a person intentionally allow his name to be on the member register, number one, or intentionally allow his name to be used by the company as a member or as a director. Although he is not the member, he is not the director, but he allowed the company to use his name as a member. Then he will be liable to the creditors, same as he is the member. The liability arises from his assets to assent to remain on the register, and he is therefore stopped from denying that he is not a member or registered without his consent. So, membership by estoppel, in fact, he is not the member. But in law, he will be deemed to be a member, where although he is not the member, he has not purchased the shares, but he allowed his name to be used by the company as a member or as a director, or his name is entered with his knowledge, with his consent on the members register. So all the liabilities of the members will be applicable on that person. So such membership is called as membership by estoppel. It is a unique type of membership. That is the end of today's lecture, number 7. In this lecture, we discuss different modes, different ways to become a member of a company. It is very simple, just 5 different modes. Membership by subscription, they are the founding fathers of the company, most important. Second, by application, just give an application, the court will allot him allotment of share, so that is acceptance and he's become member. By transfer, existing member transfer his share to a stranger and he will become the member. By succession, that is by inheritance, by operation of law, and by acquisitions or estoppel, where a person intentionally allow his name to be used by a company as a member or director, then afterward he cannot deny it, so he will be treated as a member. Thank you very much, but still if you feel any problem in this lecture, you can contact me on my WhatsApp number 0300 573967, or you can also contact me on my email. My email address is Safarat Ahmad, SAFARAT AHMAD 87 @gmail. Thank you very much and Allah Hafiz.